89.3. 4CRB.
And a very good morning to you. It's John Fradgley from the Bell Legal Group, back with you for another program of The Law and You this Tuesday morning. As always, it's your opportunity to get free legal advice between now and 10 o'clock. All we'd like you to do is get on that telephone as soon as you possibly can. 55208888 is our talkback number. That number again, 55208888. Don't forget, if you're south of the Tweed River, you need to put 07 in front. Otherwise, north of the Tweed River and throughout Queensland, you'll get straight through. 55208888. And also don't forget that you can use our email, talkback@4crb.com. If you're not in a position to make a telephone call, I do have an email that's arrived in fact came in on Friday of last week, in readiness for today's program. So thank you very much to Greg, who sent that email in. But for those of you who may not be able to get to the phone but would still like a question answered, not today, but probably in next week's program, you can send it through on that email address, talkback@4crb.com.au. And what a beautiful day it is outside after the wet weather we've had for the last, it seems like forever, that the weather has, that the weather's been out. But, sorry, I've just been reminded that our email address doesn't have AU at the end. It's just talkback@4crb.com. So my apologies there. Make sure if you're going to be emailing through, it's just talkback at 4crb.com. And with the weather the way it is outside, I wouldn't be surprised if we don't get a lot of callers today. Everyone will be outside wondering what that big glowing globe is up in the sky, and of course that's the sun that we haven't seen for such a long time. Thank you to the callers who called through last week with some interesting questions, and of course we also had someone who came through last week on the email as well, on the talkback email. So that's always good to see that people are starting to get the hang of using that. But enough of that. We'll go to our first email this morning, which is one from Greg. So if you're listening, Greg, he writes, when the court has approved a property settlement, can an ex-spouse make any claim against any financial success that may occur after the date of stamping? Now, I assume by date of stamping you mean the date that the court approves the property settlement agreement. And as I've said in previous weeks, I'm not an expert in family law, so but I will double check on this and comment again next week. But as far as I'm aware, once the court approves a property settlement agreement between parties, that's it. So the only thing I just want to check on is whether there can be any appeal after that decision, but I have it in the back of my mind that that's not possible as long as full disclosure has been made by both parties. Now, so the long and the short of it is that if you were lucky enough 6 months after the property settlement has been completed to win lotto, to the best of my knowledge, that would not be grounds for reopening a property settlement that has been made with full disclosure prior to that date. But as I say, I'll check on that with either Alex Wynne or Margaret Miller in our office, and I'll comment on that again next week if there's any changes to that, but I certainly don't believe so. One of the things that I wanted to talk about while we're waiting for some callers to come through, and don't forget that number 55208888 is the number, 55208888, is the massive increase that we've been seeing in claims against estates, people who are making claims for provision out of estates. And it has just been rising exponentially, and it just seems that year on year there are far more claims being made on deceased estates than there ever were before. I remember commenting some time ago that, or in fact some years ago, I think probably around about 5 years ago, saying that that in that year I had seen more claims in that 5 year period than I'd seen in the previous 30 years of practice. Claims against estates were relatively unusual many, many years ago, but they are certainly increasing in prevalence, and now we're seeing claims virtually coming up as often as one a month, where people's wills are being challenged. And the reason for that, of course, is that with the increase in the complexity of relationships, it's only going to lead to a greater rise in those sorts of claims. And so in situations where where a spouse has passed away and the survivor remarries and there are children of the person they remarry, those sort of situations, or alternatively if there has been a breakdown in a relationship and either or both of the parties then repartner with people who have children. It is only logical that is going to lead to an increase in the number of claims that are made. Also the breakdown in family relationships in those situations where a husband and wife separate. Invariably, in the majority of cases, there is going to be a decision made by children that there is right on one side and wrong on the other, and that can lead to a complete breakdown in the relationship between a parent and their child because of what's happened in the marriage. And that, of course, will resurface at a much later stage when that party passes away, because that is often when you will find that disgruntled child will come out of the woodwork and all of a sudden decide that they are going to make a claim on your estate. We have a matter at the moment in our office where, despite our very, very strong recommendations to the testator that he should include provisions in his will as to why he had excluded a child, unfortunately he consistently refused to take that advice, and the result has been that within days of his passing, there's been notification of intention to claim on the estate. Now, there is no one who can give you a guarantee that there will not be a claim on your estate, but what you really need to do is that if you are in that situation where it's likely or it's possible that there might be a claim on your estate from a child of a previous relationship or some other party who is dependent on you that you've chosen to exclude from your will, it is absolutely critical that you do as much as you possibly can if it is your desire that they should not receive a benefit. Because simply saying, oh, well, look, I won't worry about it, I won't be around afterwards, what you're basically doing is leaving open the real possibility of that claim, but more importantly, the loss of a significant part of your estate in legal fees that will be paid to lawyers fighting out that claim, because the executor of your will has an obligation to uphold the terms of your will, and of course you'll have a lawyer on the other side who's fighting tooth and nail for a disgruntled beneficiary who believes that they should have received provision out of your estate. So the short advice to that is you can be, what do they say, a penny foolish and a pound wise. So certainly be wise in spending that little bit of extra time and money in making sure that you get your estate planning affairs in order now to save a multitude of pain for those that are left behind after your passing, not to mention possibly tens or hundreds of thousands of dollars being thrown away in unnecessary legal fees because you haven't bothered to spend that little bit of extra time and effort and money at this particular time. But we're still waiting for some calls to come in. As I expected, a very quiet morning this morning. No calls online at the moment. 55208888 is the number. If you have a question or a query and you'd like to get straight through, as I say, 55208888, you can actually be our first caller for the morning if you get on that telephone right now. We'll be back after a word from our sponsor.
Are you serious about losing weight? VitaDiet has been helping Australians lose weight and live healthier since 1987. All VitaDiet shakes, soups, bars and desserts are gluten-free, made in Australia, and have been perfected over 30 years. There is a VitaDiet eating plan, and yes, you do eat real food. Plus, use the VitaDiet ketone sticks to gauge your fat-burning performance. To find out how you could lose up to 3 kilos in your first week, visit vitadiet.com.au for your local pharmacy or call 1300 Shakes. VitaDiet. Time to try it?
Our sponsor.
Harvey Norman Bonus Wolf Blast Wine Offer. Spend $399 or more on selected electrical products in one transaction and receive a bonus 12-bottle case of Wolf Blast Silver Label Wine valued at $300. Or spend $1,500 or more and receive an additional bonus case of Wolf Blast Silver Label Sparkling Brut. Choose from a range of washers, TVs, fridges, audio, coffee machines, vacuums, dishwashers, cooking and small appliances. Bonus Flyer Redemption. Great electrical deals plus bonus Wolf Blast Wine Offer only at Harvey Norman, South Tweed.
Another sponsor.
You're in tune with 4CRB 89.3 FM. The program is The Law and You. The telephone number 55208888. That number again 55208888. If you have a question or a query that you'd like answered this morning, please don't leave it to the last 10 minutes or 5 minutes of the program, when quite often we do get a flurry of calls coming through. If you have a question, get on that telephone right now. The lines are completely free, so you'll be able to get straight through 55208888. Something that I had mentioned is that come the 1st of October, and it reminded me when I was thinking about the fact that we've only got 169 days to Christmas, and that is that from the 1st of October this year, the system of having a paper title in Queensland, so a paper certificate of title for your property, will no longer apply. So the amendments which were made back in March, I think the 26th of March, to the Land Title Act 1994, now specify that that as of that date, 1 October 2019, paper titles will be relegated to history. And so even if you presently have a paper certificate of title, it's my understanding that you won't need to produce that document for land transactions after the 1st of October. You can still get a paper title if you particularly want one, but those applications will no longer be dealt with through the regional offices. Up until that date, they will be dealt with from the head office of the Titles Office in Brisbane, and also from, I think, perhaps one or two other regional centres, but not from the Gold Coast. So that's a big change. Sometimes it has been a problem where a title deed is lost and there was a paper title issued, because at the moment, when you get a registration confirmation statement for a land transaction, it will state whether there has been a paper title issued or not. There'll be a notation on it, certificate of title issued, yes, or it'll have certificate of title issued, and then it'll have yes or no. And that, of course, on the search is what determines whether there is a paper title in existence. And if there is one, then, of course, even now you must produce that paper title if you're going to sell that property. Otherwise, the buyer of the property would be entitled to refuse to settle if you're unable to produce the title deed on the day of settlement. Come 1 October, that, of course, will no longer be the case. And those paper titles, I suppose, if they're not required to be produced, you could probably hang on to it and maybe get it framed as a piece of history. I know we've got some very old certificates of title and, in fact, land grants that have been framed in our office that go back as far as the around about the 1890s. Just as a little bit of history for Queensland, or Australia, in fact, on the walls around the office. So just bear that in mind. 1 October, no more paper titles required. But if you do particularly want a paper title for a property you own and you presently don't have one, then you must make that application well prior to 1 October this year. Otherwise, that's not going to happen. We have just been advised too, by the way, say that the reason why we don't have any callers coming through this morning is because, in fact, our telephones are down just for a change. Since we put this new phone system in, we seem to have been having a few little problems with it, which I'm sure they're getting to the bottom of, but nonetheless, that's the reason why we're not having anything here at the moment, so no calls coming through. So if you can save up those calls until next week, that would be quite useful if you could do that. Well, we'll be back again after a word from our sponsor.
Independent Wealth Management is one of the few completely independent financial planning practices in Australia. IWM is a financial planning firm specialising in self-funded retirees here on the Gold Coast, a member of the Financial Planning Association of Australia and the IFAAA. IWM does not take or receive commissions, inducements or fees from third parties and aren't owned by a bank or insurance company. Phone 5636 3800. Australian Financial Services Licence 493459. A sponsor.
When booking your next cruise or travel, remember the best. Our sponsor, Globetrotters Cruise and Touring. It's the little things that count that make us stand out. Tweed City Shopping Centre, Mingeable Drive, Tweed Heads.
This is 4CRB 89.3 FM. The Law and You is the program. Unfortunately, you presently cannot call us. The only way that you will be able to get through for the program, unfortunately, will be via our email, talkback@4crb.com. I'm just having Chantal check to see whether we've had any other emails come through, but it appears not. One of the other things too, that it's probably worth mentioning with the 30th of June just passing and talking about property and paper titles, etc., has reminded me about is that if you've sold a property in the last 12 months and that property was not your home, your principal place of residence, it may be that you're in fact liable for capital gains tax on that property. And so therefore, if you're getting ready to do your tax, don't overlook the fact that if you have sold a property, depending on the circumstances, it very well may be that there is some capital gain in that property that needs to be brought to account, particularly if it's a property which was purchased after the introduction of capital gains tax in September 1985. Or if it's a property that you've inherited since that date, even if it was a pre-September 85 property, if you've inherited that property since that date and it has not been occupied as a principal place of residence for the whole time, then it may be that there is some tax to be brought to account in that. So just a little reminder there, you don't want to end up on the wrong side of the tax man if you can possibly avoid it. The telephones are back up and we've got our first caller for this morning. As we say, a very good morning to Judy. G'day, Judy. How are you?
Hi. Is that you, John?
It is indeed. How can we help?
Yes. My question is, I have a daughter. Haven't spoken to her nearly in 20 years. Mm-hmm. I have been to the solicitors and have made that extra document to say that I don't want to
leave her anything. Yeah, so you've made basically what we refer to as a statement of testamentary wishes,
That's
which
correct.
is basically a declaration as to why you're not making any provision for her. Yes.
I have tried my hardest to be in touch with her every single way, even went all the way to Sydney, knocked on the door and she screamed at me and said she'd get the police and everything and never even opened the door, which was very upsetting.
Yes.
But my question is, if she did contest the will, what sort of money would she be looking at?
Well, look, in the circumstances...
She is a psychologist.
Sorry, she's a psychologist.
Yes.
Right. In the circumstances, it worries you that she's a psychologist and she behaves like that.
Yes.
But look, in the circumstances you describe, Judy, I think it would be unlikely that she would be successful in any claim. I mean, if she has basically demonstrated quite categorically that she does not want to be any part of your life, she has not been financially dependent on you, obviously,
not
for
now.
many years.
I put her through Bible college and university.
Yes. Oh, it's good to see
Then
that
I
the
stood
Bible
up.
college really did did some work on her, that's for sure. But that's very, very disconcerting. Look, no one can give you a guarantee that she will not bring a claim against your estate, Judy, and the the time we have in this program is not sufficient to go fully into your circumstances. But if you've made a will and you've also had a statement of wishes prepared, which clearly sets out the reasons why you're not making any provision, and if you haven't already done it, I would also perhaps update the statement of wishes to include your recent visit to Sydney and what happened in that attempt to make contact. I would say that the chances of her being able to successfully claim would not be very high at all. And the other side of it is that she would have to also be extremely careful in bringing a claim, because the courts are becoming more willing to make orders for costs against children or people who bring claims in circumstances where it's clearly not, there's no basis to the claim, or they do not have any moral basis upon which they can make a claim. So she would have to be quite careful that she didn't end up on a wrong end of the order of an order for costs to pay your executors on your death. All right then?
Yep. Thanks very much.
Okay, Judy, all the very best. And we say a very good morning to Max. Good morning, Max. How are you today?
Good morning. Good, thanks.
How can we help?
My wife and I have decided that we do not wish to go into residential care at any stage in our life.
Yep.
Whether we lose capacity or not.
Yep.
And I'm wondering if we can direct our power of attorney to use our estate entirely for the purposes of maintaining us in our own home.
Yes.
And if one dies first, well, clearly one will die first, then in that will that our estate only be used for the purpose of maintaining the survivor in their own home.
Well, what I would suggest you do, Max, is this, that you would need to very clearly you would have to choose your attorneys very carefully, firstly, and make it very clear to them, perhaps with specific provisions in your power of attorney, to say that you and your wife are to be maintaining your home, even if that means spending the whole of your estate on the cost of doing that, in providing 24-hour care if that became necessary. Secondly, if you have wills which leaves the whole of your estate to each other, then I don't think you need to worry about saying that the estate of the first to die is going to be spent on maintaining you in the home, because clearly if the estate goes to the survivor's already got a power of attorney which clearly articulates to the attorneys what they're to do. And you may even be able to include some of that in in an advanced health directive as well. The one thing though, Max, that you just need to bear in mind is that if a doctor recommends that, or makes a recommendation that you go into care, for example, if you're in hospital and the doctor says, I will not agree to release you back to your home, even if you've got 24-hour care, you may not have a choice in it. But I think that's probably unlikely if you're able to afford the level of care where it can be clearly demonstrated to the hospital that you're getting as good a care, if not better care, at home as you would receive in a care facility. And I don't think probably if you've got proper care in place that would be terribly difficult to show. All right then.
Okay, thank you very much.
Okay, Max, all the very best. And we'll say a very quick hello to Jack. G'day, Jack. How are you today?
Not too bad at all, thanks.
How can we help?
Going to your short session before about the titles to our land, our land and so on, the paper titles are going to be extinct as of the end of October.
Only in Queensland.
Only in Queensland. We are in Queensland.
Right.
All right. I know that I'm probably acting the devil's advocate on this, but what guarantee do we have that if we ring up the titles office and say, look, my name's Jack Vinton, I live in so-and-so and so-and-so, we own our property free and clear, what's the reference number within the electronic system? If somebody else gets into the system for nefarious means, as they would say, and decides to remove our name and put theirs in, what guarantee do we have that we...
The system now, Jack, I would have probably a few years ago I would have shared your concerns, but the system now is such that it is virtually impossible to do anything with property unless you can clearly establish that you are the owner, and that comes down to producing your driver's licence, other evidence to show that you are the owner of that property. So it's not just a case that you can ring up and say, I'm Bill Smith and I want this property in my name, or even go into the titles office. The titles office they won't change the title because you're already on the title. Whether you've lost your title deed or not, the title is still in your name. And if you can't produce evidence to prove that you're that person when you sell the property, then the short answer is that you simply can't sell it, and you can't mortgage it either. You can't borrow money against it. But Jack, we'll have to leave it there, unfortunately, because we're just pressing up to the news. But rest assured, I think it's all going to work okay.
All right, thanks for your time.
All the best. This is John Fradgley from the Bell Legal Group. It's been great to be with you for the Law and You this morning. Hopefully next week the phones will be up and running without any problems like we had earlier in the morning. But until then, I'll look forward to seeing you next week. Goodbye and God bless.